The University of the Visayas Prayer. Lord, fill our hearts with your precious gifts. Let us overcome our weaknesses with your strength this very day, that we may fulfill all the duties of our state conscientiously, that we may do what is right and just. Let our charity be such as to offend no one and hurt no one's feelings, so generous as to pardon sincerely any wrong done to us. Lord, grant us the serenity to accept the things that we cannot change, courage to change the things that we can, and wisdom to know the difference. Graciously hear us, O Lord, and pour your light into our hearts and minds. Assist us today to grow in goodness and grace. Amen.
Proudly we stand to thee, alma mater, flame of love that beams shining brighter. Hell we shout, we cheer forever. Love and service all we uphold. It's the pride of dear Visayania. Joyful hearts we sing together. Seek the truth, the fountain of knowledge. Long live alma mater dear. Visayas, go, go, go! Love and serve humanity. With the heart we love to see. We will always lead the way as to thee. We say onward, keep the UV spirit burning. Our beloved dear alma mater. With our hearts we pray forevermore. Visayas, go, go, go! Love and serve humanity. With the heart we love to see. We will always lead the way as to thee. We say onward, keep the UV spirit burning. Our beloved dear alma mater. With our hearts we pray forevermore.
The University of the Visayas Vision and Mission Statements. The University of the Visayas envisions to become an internationally recognized private non-sectarian university committed to academic excellence, transformational, and innovative education. To attain its vision, the University of the Visayas lives up to the following functional strategies. Research. The university will build and embrace a sustainable research culture among students, faculty, and non-teaching staff in support of its academic programs and community extension thrust. Instruction. The university will develop the talents and potentials of the students towards the practice of professions to be responsive to the changing local and global industry requirements. Extension. The university will capacitate a community guided by the University Extension Program and be a catalyst for social transformation. Values. The university will develop a community of God-centered, nationalistic, and globally competitive professionals with proactive values and attitudes. The University of the Visayas core values: lead and serve. L. Leadership. E. Empathy. A. Achievement. D. Discipline. S. Service. E. Environmentalism. R. Respect. V. Virtuousness. E. Excellence.
Good day, everyone, and welcome to Persons and Family Relations. We are now on Article 3 of the Family Code, which provides for the formal requisites of marriage. To recap, we have discussed that in order for a marriage to be valid, parties must comply with both the formal and the essential requisites of marriage. We have already discussed the essential requisites of marriage as follows: the legal capacity of the contracting parties, who must be male and female, and the second one, consent freely given in the presence of the solemnizing officer. Today, we shall endeavor to discuss Article 3 of the Family Code. Article 3 of the Family Code provides the formal requisites of marriage. The formal requisites of marriage are the authority of the solemnizing officer, a valid marriage license except in cases provided for in Chapter 2 of this title, and a marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than two witnesses of legal age. So let's start with the first paragraph. The first paragraph provides that in order to comply with the formal requisites of marriage, there must be an authority of the solemnizing officer. Now, the question would be this: who are authorized to solemnize marriages? Article 7 of the Family Code answers this question. Niingon ang Article 7: a marriage may be solemnized by any incumbent member of the judiciary within the court's jurisdiction. Number 2, any priest, rabbi, imam, or minister of any church or religious sect duly authorized by his church or religious sect and registered with the Civil Registrar General, acting within the limits of the written authority granted him by his church or religious sect, and provided that at least one of the contracting parties belongs to the solemnizing officer's church or religious sect. Third, any ship captain or airplane chief, only in the cases mentioned in Article 31. Any military commander of a unit to which a chaplain is assigned in the absence of the latter during a military operation, likewise only in cases mentioned in Article 2. Or number 5, any consul general, consul, or vice consul in the case provided in Article 10. So let's start off with the first paragraph. Any incumbent member of the judiciary within the court's jurisdiction. Now, Article 8, you should relate this paragraph with Article 8. Article 8 provides the marriage shall be solemnized publicly in the chambers of the judge or in open court, in the church, in the chapel or temple, or in the office of the consul general, consul, or vice consul, as the case may be, and not elsewhere. Okay? Not elsewhere, except in cases of marriages contracted in the point of death or in remote places in accordance with Article 29 of this code, or where both parties request the solemnizing officer in writing, and in which case the marriage may be solemnized at a house or place designated by them in a sworn statement to that effect. Unsa may pasabot ani? Anong ibig sabihin nito? When we talk about justices of the Supreme Court and justices of the Court of Appeals, can they solemnize marriage? Yes, they can. But up to what extent? Ang scope nila is national, okay? So anywhere in the country, they can solemnize marriages. But when we talk about RTC judge or MTC judge, as the case may be, yung kanilang jurisdiction is territorial. Meaning, kung ang scope sa RTC, let's say Cebu City, so they can only solemnize within the territorial district. Alright? If it's MTC, it's just in the municipality. But if solemnizes outside the jurisdiction, suppose an RTC judge would solemnize a marriage outside of his territorial jurisdiction. Is the marriage that is being solemnized by that judge be considered, will it be considered valid? That is the issue in the case of Navarro versus dumagtoy. Okay? What happened in Navarro versus Dumagtoy is this. The municipal mayor of Dapa, Surigao del Norte, Rodolfo Navarro, filed a complaint on specific acts committed by the respondent, Municipal Circuit Trial Court Judge Hernando Dumagtoy, on the grounds that there was gross misconduct, inefficiency in office, and ignorance of the law on the part of the respondent, Judge Dumagtoy. Now, what happened here, as alleged in the petition, was that the judge solemnized the marriage of Floriano Somailo and Gemma de Rosario outside his court's jurisdiction on October 27, 1994. The judge actually holds his office and has jurisdiction in the Municipal Circuit Trial Court of Santa Monica, Burgos, Surigao del Norte. But he solemnized the said wedding, at his residence in the municipality of Dapa. The municipality of Dapa is actually located 40 or 50 kilometers away from his office. Now, the issue actually involves the solemnization of a marriage ceremony outside the court's jurisdiction covered by Article 7 and 8 of the Family Code. And the question is posed in this manner. Is the marriage valid according to these articles? How did the Supreme Court decide on this issue? Let's find out, no? So, the Supreme Court said that the more important or the elementary principle underlying this provision is the authority of the solemnizing judge. Under Article 3, one of the formal requisites of marriage is the authority of the solemnizing officer. Under Article 7, marriage may be solemnized by, among others, any incumbent member of the judiciary within the court's jurisdiction. Now, Article 8, according to the Supreme Court, which is a directory provision, refers only to the venue of the marriage ceremony and does not alter or qualify the authority of the solemnizing officer as provided in the preceding provision. And non-compliance herewith will not invalidate the marriage. A priest, according to the Supreme Court, who is commissioned and allowed by his local ordinary to marry the faithful is authorized to do so only within the area of the diocese or place allowed by his bishop. An appellate court justice or justice of the Supreme Court has jurisdiction over the entire Philippines to solemnize marriages, regardless of the venue, as long as the requisites of the law are complied with. However, judges who are appointed to specific jurisdictions may officiate in weddings only within the said areas and not beyond. Where a judge solemnizes a marriage outside his court's jurisdiction, there is a resultant irregularity in the formal requisite laid down in Article 3, which, while it may not affect the validity of marriage, may subject the officiating official to administrative liability. Further, the Supreme Court said that as respondent judges' jurisdiction covers the municipalities of Santa Monica and Burgos, he was not clothed with authority to solemnize a marriage in the municipality of Dapa, Surigao del Norte. And by citing Article 8 and the exceptions therein as grounds for the exercise of his misplaced authority, respondent judge again demonstrated a lack of understanding of the basic principles of law. In short, guys, if si judge nag-solemnize outside sa iyang jurisdiction, valid gihapon na siya. But of course, this is without prejudice to the administrative liability that the judge may face. Okay? Now let's go to the second paragraph of Article 7. It says, any priest rabbi, imam, or minister at any church or religious sect duly authorized by his church or religious sect and registered with the Civil Registrar General, acting within the limits of the written authority granted by his church or religious sect, and provided that at least one of the contracting parties belongs to the solemnizing officer's church or religious sect. Example, a Catholic priest, no? There's a Catholic priest authorized to solemnize a marriage. However, the parties are ang male, Iglesia ni Cristo, ang female, dating daan. And then they went to the Catholic priest. Will the priest be considered authorized to solemnize their marriage? The answer is no, because neither of them belongs to the church over which the said priest belongs, except of course when they or either of them believed in good faith that the solemnizing officer had the legal authority to do so. That is provided for in Article 35, paragraph 2, which we will discuss extensively later, okay? Paragraph 3. Any ship captain or airplane chief, only in the case mentioned in Article 31. Timanin that these will only be applicable in marriages in Articulo Mortis, okay, provided for in Article 31. And it's noted there in Article 31, a marriage in Articulo Mortis between passengers or crew members may be solemnized by a ship captain or by an airplane pilot, not only while the ship is at sea or plane is in flight, but also during stopovers at ports of call. But kini, for example, diri sa Gulyas Law School na kay naibugan. And then, panguyaban mo, gisugot ka, however, nadunggaban ka. This is just an example. And then, you are already in articulo mortis on the verge of death. And then, you have a classmate who is a ship captain. Can the said classmate who is a ship captain solemnize your marriage? Pwede ba mo niya nga kaslon? The answer is no, because in Article 31, it's very specific, okay? You have to be a passenger or a crew member of the ship or of an airplane over which the said ship captain or airplane pilot is the captain or the pilot, okay? Although naingon siya not necessarily on the ship or on the sea, but it can also be during stopovers or port of calls, but it's very specific that this can be done only between passengers or crew members, okay? Not a member of the Gulyas Law School. So that's an example there. You have to be very careful with the provision of Article 31. Also, paragraph 4 provides that any military commander of a unit to which a chaplain is assigned in the absence of the latter during a military operation, likewise in the cases mentioned in Article 32. Pareha gihapon ha. In Article 32, it provides a military commander of a unit who is a commissioned officer shall likewise have the authority to solemnize marriages in articulo mortis between persons within the zone of military operation. Basta within the zone of military operation, whether members of the armed forces or civilians. Also, paragraph 5 provides that any consul general, consul, or vice consul in the cases provided for in Article 10 may also solemnize marriage. Ang Article 10 provides that marriages between Filipino citizens abroad may be solemnized by a consul general, a consul or vice consul of the Republic of the Philippines, and the issuance of the marriage license and duties of the local civil registrar and that of the solemnizing officer with regard to the celebration of marriage shall be performed by the said consular official. Also, specific kain ni siya guys that these will only apply to marriages between Filipino citizens who are abroad, okay? And lastly, there's an inclusion there, the mayors of city of or municipality as provided for by the local government code. So we now go to the second formal requisite of marriage. That is a valid marriage license, except in the case provided for in Chapter 2 of this title. The exception, ladies and gentlemen, will be discussed later on in our study, okay? Article 9 provides that a marriage license shall be issued by the local civil registrar of the city or municipality where either contracting party habitually resides, except in cases where no license is required in accordance with Chapter 2 of this title. Actually, earlier we've discussed some of the instances wherein a marriage license is not required. Katong mga marriages in Articulo Mortis, marriages in remote places, marriages between Mohammedan brothers, and other marriages provided for by law wherein no marriage license is required. Okay? Now, the license, ladies and gentlemen, shall be valid in any part of the Philippines but only for a period of 120 days from the date of issue. Okay? And it shall be deemed automatically canceled at the expiration of the said period if the contracting parties have not made use of it. And the expiry date here, if some of you here are already married, you would know that it shall be stamped in bold characters on the face of every license issued. Alright? Now, third paragraph of Article 3, it provides a marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Now, the question is there a required form of marriage ceremony? The answer is no, okay? Article 6 provides that no prescribed form or religious rite for the solemnization of the marriage is required. And it shall be necessary, however, that for the contracting parties to appear personally before the solemnizing officer and declare in the presence of not less than 2 witnesses of legal age that they take each other as husband and wife. Okay? There has to be a personal declaration and it must be before 2 witnesses. Now, some authors would say na 1 witness would be enough, or even if there be no 2 witnesses, okay ra. And even if there be no witnesses at all, okay ra. Because the premise here is that there can be no marriage naman if there's walay solemnizing officer, diba? If there's no solemnizing officer, wala may marriage na mahitabo. So I think I would subscribe to some authors wherein even if there be no really official 2 witnesses, as long as there's a solemnizing officer and a marriage actually took place, that would be enough to consider the marriage valid. But suppose the absence is on the part of the ceremony. There's no ceremony. Niingon ang Supreme Court, to be under the mantle of the family code, there must be a semblance of ceremony. If wala na, it's as if you're not married to each other. Okay? Example, ani, there was a case wherein a mayor, wala siya sa iyang office. What happened here is maybe si mayor nagtago-tago kay gireklamo bahin sa SAF, wala siya. What the secretary of the mayor did is she just let the mayor sign the marriage certificate. Will that marriage between the parties be considered valid? No, because it's as if there was no marriage at all, diba? The Supreme Court, the law would provide that there must be at least a semblance of ceremony. If wala na, it's as if no marriage actually took place. Okay? So again, what are the formal requisites of marriage? These are the authority of the solemnizing officer, valid marriage license, a marriage ceremony, and also note of the related articles discussing or explaining these requisites provided for in Article 3. All right? So now on to Article 4. Article 4 provides the absence of any of the essential or formal requisites shall render the marriage void ab initio, except only as stated in Article 35, paragraph 2. A defect in any of the essential requisites shall render the marriage voidable as provided in Article 45. An irregularity in the formal requisites shall not affect the validity of the marriage, but the party or the parties responsible for the irregularity shall be civilly, criminally, and administratively liable. Tanawa ha, absence of any of the essential or formal requisites shall render the marriage void ab initio. Okay? What is meant by void ab initio? Will it be considered void from the very beginning? Nagkanang nag-argue ane, but it doesn't really mean void from the very beginning. Ano man? Because as long as there's a semblance of marriage, naaman gihapoy legal consequence, di ba? Or nagyapoy effect ang marriage. Okay? Naman siya gitawag nga presumption of validity. Ganun kayo magkang there's a presumption of validity? Because you have to go to court first before you can declare it as void or before you can declare it null and void. Diba? You have to obtain a court order declaring said marriage void. And of course, later on, ang consequence is makita na nimo only in with respect to the property regime, with respect to the status of your children. Because if later, if your marriage will be declared null and void, you will see the difference kung unsa ang property regime. If later your marriage will be considered null and void, you will see the difference with respect to the status of your children. So mo na siya, but you cannot really say na it is really void from the very beginning because at some point naagihapoy consequence or there's an effect with respect to the marriage because you will have to wait for a court order to say that it's really void from the beginning. All right? Now, you have to note nga absence of any of the essential or formal requisite, klaro kaayo na it is considered nga ang marriage ana is void ab initio. Kung defect lang on the essential requisite, ang mahitabo sa marriage is avoidable. Okay? Kung irregular siya ang formal requisites, ang mahitabo it will not affect the validity of the marriage as discussed earlier atong Navarro versus Dumagtoy, but ang party or the parties responsible for the irregularity shall either be civilly, criminally, and administratively liable. Okay? Okay, note that in paragraph 2 of this article this is restrictive because not all defects ang iyahang gihisgutan here, but only those that are enumerated in Article 35. Also note that in paragraph 3, irregularity in the formal requisites. Okay, as earlier mentioned, dili na siya maka-affect sa validity sa marriage, but it will hold the person or parties responsible for the irregularity to a civil, criminal, or administrative liability. Okay? So you would notice that by just discussing articles 3 and 4, daghan kayo tag mga articles nga na relate. Okay? I hope you learned something from this discussion. If you have questions, feel free to message me via Messenger or via Teams and ask me those questions. Thank you very much. Amping.